Hey everyone, Harry here to talk about a lawsuit pending in federal court in Texas that providers of reproductive health services fear could be, quote, catastrophic and could affect the reproductive rights of women even more than the Dobbs decision in the Supreme Court overruling Roe versus Wade. All right, the case actually concerns the medication that is now the regime of choice for over 50% of women who elect to terminate their pregnancies. It's a two-step process involving two different drugs. The first one you take is called mifepristone, and that basically stops the growth or continuation of the pregnancy. It's followed by a drug called misoprostol, which brings on cramping and bleeding and the end of the pregnancy. The lawsuit is brought by a self-styled group called the Alliance Defending Freedom, one of those euphemistic names. And they are challenging, in particular, the mifepristone, the first drug one takes to facilitate the pregnancy with the additional administration of misoprostol. And important to note, you can terminate a pregnancy just with misoprostol. However, it is harder, more painful. It takes longer, and if that is what was available, it would really impair this regime quite a bit. But the Alliance Defending Freedom is going after the FDA approval of mifepristone. In other words, they're going after the drug that, if they're successful, won't prevent abortions, but it'll just make them harder, more painful, more arduous, and the like, which seems, almost sadistic. All right, but this case is pending in the courtroom of a judge who has been handpicked for his hostility to reproductive rights. Even before the Dobbs decision, he was well known for his opposition to Roe v. Wade. And the argument that the challengers are making, they have sued the FDA, saying way back in 2000, when the FDA first approved mifepristone, it didn't cross its T's and dot its I's properly. In particular, it ignored certain issues with the drug, and it in order to approve it, it needed to characterize pregnancy as an illness that this drug actually could help treat. So they are basically saying the FDA got it wrong according to the FDA's own procedures. You take a step back and realize how sort of far-fetched and wrong-headed this suit is. The whole point of the FDA is to have a consistent nationwide regime to ensure the safety and efficacy of drugs in this country. And the FDA has repeatedly found that mifepristone is safe and effective, not just in 2000. You need something like that. Here, if I can give a sort of what'll seem a far field metaphor, but people may know that even though marijuana is legal in many states, it still remains illegal under federal law. That's basically an FDA point. Basically, the federal government, if ever called on to defend it, and it doesn't seem as if it would say, look, we need a standard regime for categorizing drugs. Otherwise, you could have, individual states say that wacky, say cancer treatments or off-label uses of drugs are okay in Georgia. You could go to Georgia to get Latril, as a treatment for cancer, made from apricot pits, or you could have, specific, really unsafe and ineffective regimes be have individual states approve them. The whole point of an FDA is to have a national standard about safety and efficacy, and that's the whole point of this regime of the two-pill Medicaid process, which A is safe and effective, and B, as I've mentioned, you could still women would still be left with the possibility of having the medical termination of abortions, medical termination of pregnancies, but it would just be much harder, more painful, etc. And of course, in states in which abortion has been outlawed, there's the really grave risk that they could have complications and not want to go to the hospital because because it's unlawful. So it really is just a kind of mean-spirited attack to make it harder for women to employ the procedure of choice for over half today in this country, and even more, by the way, for early pregnancies in the first 10 weeks. It's really the procedure of choice. Now, the Department of Justice, remember OLC opinions, which came up, in the Trump administration, they issued in January what you might call, if you're a proponent of reproductive rights, a good opinion saying that it is permissible to send medication through the mail. So as of now, the federal government is protecting the rights of women, even in states where abortion is now subject to draconian restrictions, to get these pills in the mail. It gets a little tricky in the states to actually take them. Now maybe state authorities would try to prevent it, but as a practical matter, if you can send away for these, for this two-pill regime, it's going to be, awfully hard for a state to interdict it. So it really is a huge kind of safety net in the wake of not just the Dobbs case, but state regimes that are imposing really, really strict restrictions on women's choice. So that is, the DOJ is involved here somewhat. Yesterday, when the Attorney General testified before the Senate Judiciary Committee, he made a point of saying one of the priorities of the department is to protect reproductive rights. There's a whole working group, and it is they who have devised the policy of saying you can get medication in the mail and trying to do other things. All right, but the concrete worry is that this lawsuit goes to this district court judge who finds that the FDA didn't comply with its own procedures. That's really not a basis for striking down the approval, especially in light of the repeat findings by the FDA that the two-pill regime is safe and effective. But that's the worry, and the whole thing has been handpicked not simply for this one district court judge, but an appeal from him would go to the Fifth Circuit, which is arguably the most conservative circuit in the country, especially where reproductive rights are concerned, and from there, the Supreme Court. So providers foresee a potential catastrophic, their word, scenario where one little judge in Texas says, FDA didn't quite do it right, and it zips through the federal court system, and presto changeo, mifepristone is no longer available, and even though the one pill remaining, misoprostol, could still effectuate terminations, it's more dangerous, painful, and the like. So that's what has people really very, very anxious about this case. It was filed in November, so it's pending. Now it's moving to litigation, and even could be decided as judges can do just based on the allegations in the complaint. So we'll be watching that closely. I personally think that it's so far-fetched and so flies in the face of an overwhelming need for federal uniformity, where categorization and regulation of drugs is concerned, that at least the Fifth Circuit and the Supreme Court would never countenance it. But I've been wrong before, and obviously once burned, twice shy for a lot of providers who saw, the world turned upside down by the court last year, and is, looking very seriously at the repercussions. And there's no doubt that the point of the lawsuit is to try to make this happen. So we'll keep looking at it. Should the district court enter this finding and maybe even try to enjoin the FDA from using mifepristone going forward while the case is pending, that would be big and bad news. And so this is a case worth following, and we will here at Talking Feds. Wanted to mention, if you find these videos useful, helpful, informative, fun, whatever, please like and subscribe. We're an entirely independent organization, and it helps us a lot. Okay, but looking forward, we'll see what this one district court judge will do with this FDA challenge to the most important current contemporary regime for terminating pregnancies, which becomes, of course, all the more important in the wake of Dobbs and the overruling of Roe versus Wade. Until then, talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.